Yes, Your Honor. We filed 3 motions this morning. I have a 4th motion to make orally. I'm not going to belabor them at any great length, but I didn't want to have them on file for the record. We filed this morning a motion to bar imposition of sentence of life without parole as to defendant Bryan for felony murder. That is basically, we're arguing for an extension of the decision of the U.S. Supreme Court in Edmond v. Florida, which held that individuals who are convicted of felony murder without killing, attempting to kill, or intending to kill are not eligible for the death penalty. We're pursuing that both under the 8th Amendment to the United States Constitution and Article 1, Section 1, Paragraph 17 of the Constitution of the State of Georgia. We're asking the court to extend that reasoning one step further, reflecting evolving standards of decency, and hold that the imposition of a sentence of life without parole for felony murder would likewise be unconstitutionally cruel under our constitutions, absent evidence that defendant Bryan killed, attempted to kill, or intended to kill Ahmaud Arbery. We don't believe any of those facts are in dispute in this case. That's our first motion.
Anything from the state?
Yes, Your Honor. The reason felony murder and different from malice murder is because of the lack of specific intent to commit the murder. As we all know, when a co-defendant like 2 men go into a convenience store and they attack the convenience store clerk, and the clerk, defending himself, shoots and kills one of the armed robbers. The first armed robber is responsible for the death of his friend and co-defendant under felony murder, because while there was no intent for one armed robber to kill the other armed robber, it's a matter of responsibility under felony murder, not a matter of intent to kill. And in this particular case, Mr. Bryan is eligible for this court to impose a sentence of life without the possibility of parole. There is nothing preventing this court from doing that on a felony murder charge, because felony murder, once again, is about responsibility, not about intent to kill. Thank you.
All right. Mr. Goff.
Your Honor, with all due respect to Ms. Dukowski, I don't believe that response addressed the issue. The issue is for an individual system such as Mr. Bryan, who did not kill, did not attempt to kill, and did not intend to kill, whether or not the 8th Amendment allows the imposition of a sentence of life without parole is not a question of the Georgia sentencing scheme or statutes. It's a question of federal constitutional law. Clearly, under those circumstances, the death penalty, imposition of the death penalty, is cruel and unusual. We are contending, since Edmond v. Florida in 1982, that standards and our sense of decency as a society have evolved to the point where the 8th Amendment does not allow the imposition of a sentence of life without parole for felony murder, absent killing, an attempt to kill, or intent to kill. And I don't think the state contests that those are not the facts of this case. I think the state is relying on the fact that the United States Supreme Court hasn't addressed this issue yet, at least not to my knowledge. We're preserving the issue for appeal.
All right. The court received the motion to bar imposition of sentence of life without the possibility of parole as defendant Bryan for felony murder this morning. It looks like it was filed at 8:18. I have reviewed the motion. It cites the one case that was just referenced by Mr. Goff, and having considered the arguments of counsel, the court denies the motion. Mr. Goff.
Thank you, Your Honor. Our second motion is a motion to declare unconstitutional mandatory life sentence for felony murder for a discrete class of offenders, and in the alternative, motion to bar imposition of life sentence as to defendant Bryan for felony murder. The previous motion addressed whether or not Mr. Bryan was eligible under the 8th Amendment for a sentence of life without parole. This motion challenges whether Mr. Bryan can be sentenced to a mandatory life sentence for felony murder, both as a class of individuals who have not killed, intended to kill, or attempted to kill, and also as to Mr. Bryan individually. And we contend that this is essentially, the first part of it is taking the Enman case that has already been discussed this morning, not one step, but two steps, to strike down mandatory felony murder for people that convicted of felony murder that fall within that class of individuals that have not killed, attempted to kill, or intended to kill. This is an issue which has tremendous import in the state of Georgia and around the country, in that there are hundreds in Georgia and probably thousands of individuals around the country who are serving life sentences, have been in prison for many, many years, who drove the car that was used to escape from the armed robbery, or provided the key to break into the house not knowing that it was occupied. There's all kinds of people out there across the country serving life sentences right now who never killed, attempted to kill, or intended to kill, but have been subjected to mandatory life imprisonment. I would venture to say the majority of those individuals tend to be African American, but I haven't studied it in depth in a while. But that doesn't matter. It doesn't matter whether you're white, black, or Martian. It's still wrong for the legislature to require this court, to compel this court as a matter of law to impose a mandatory life sentence on an individual who hasn't killed, attempted to kill, or intended to kill. And again, this is an issue that would have significant impact if it were granted, but we are certainly preserving that issue. Secondly, with respect to Mr. Bryan individually, we believe that he is not eligible for imposition of a mandatory life sentence pursuant to the 8th Amendment, based on the totality of the circumstances surrounding the offense, his criminal history and other circumstances, which we'll get into during the sentencing hearing, and that the imposition of a life sentence to Mr. Bryan would be unconstitutionally cruel and disproportionate. And we cite the relevant Supreme Court authorities as to that issue.
Thank you, Judge. Your Honor, the legislature has spoken not only with 1651, which imposes a mandatory life sentence for felony murder, but also with party to a crime and conspiracy. All of those laws are on the books for a very important reason, which is responsibility for your actions. And at this point, the state is asking that this court not fly in the face of the legislature or the statutes that are on the books, especially 1651, based on this particular argument that somehow Mr. Bryan is special and outside the imposition of the law. Thank you.
Any further word on that motion?
On behalf of Greg McMichael, we'd like to join that motion, but without any further argument.
It doesn't apply to us, really.
Your Honor, I don't have to object. I'm arguing, I guess. But the idea that Mr. Bryan is asking for special treatment here is just wrong and contrary to the argument actually made. Our position is that no one in America convicted of felony murder who didn't kill or attempt to kill or intend to kill should be subjected to a mandatory life sentence. That doesn't mean that a court couldn't impose a mandatory life sentence. It means that the court should constitutionally have the discretion to impose the sentence that is appropriate, and for the legislature to dictate that these individuals, such as Mr. Bryan, the court cannot consider a sentence of less than life imprisonment is cruel and unusual, and this practice needs to stop. It's gone on since before I was born, before Your Honor was born. It was wrong then, it's wrong now, and sometime, somewhere, it has to stop. Secondly, as to Mr. Bryan individually, again, it's not suggesting that Mr. Bryan is special. It's suggesting that anyone in Mr. Bryan's circumstances, under the facts of this case, anyone besides Mr. Bryan, with the same criminal history, with the same background, with the same circumstances, that imposition of a mandatory life sentence would likewise be disproportionate as to them. So this is not a request for special treatment. It is a request for individualized sentencing consistent with the 8th Amendment.
All right. Again, the motion is filed this morning. I did have an opportunity to review the motion. Having heard the arguments of counsel, the court denies the motion. Mr. Goff.
Our third and last formal written motion is a motion to vacate illegal felony murder convictions based on double jeopardy. And I don't want to be accused of plagiarizing, an inmate apparently from the Michigan criminal prison system, Mr. Sires, was kind enough to draft a motion for me to file, and even went out and found Georgia case law. Your Honor, I have to confess it doesn't quite reconcile with my memory of all of the Georgia case law, but the argument's pretty good. Mr. Bryan was acquitted of count 2, felony murder. There is only one felony murder statute, and therefore, once you've been acquitted of felony murder in count 2, double jeopardy bars conviction under counts 3, 4, and 5. The argument being that they're all different ways to commit the same offense, and we believe that under the authorities, which are not just state authorities, they're federal authorities, including Ahmaud v. U.S., 437 U.S. 54, that the court should find that double jeopardy bars imposition of sentence under counts 3, 4, and 5. Independent of that, we also have an issue with respect to the jury returned a verdict of not guilty as to the lesser offenses on count 7, and therefore the verdict on count 7 is repugnant with the verdict of the jury as to the lesser offenses. I would note, I don't recall the court asking the jury to address the lesser offenses unless and until Mr. Bryan was found not guilty on the indicted offense of count 7, but nevertheless, the jury did return verdicts of not guilty. The state did not object to the return of those verdicts at the time, and those not guilty verdicts on those 3 lesser offenses are repugnant to the conviction on count 7, and therefore count 7 should be set aside for that reason. And that is my motion.
From the state.
Thank you, Judge. Your Honor, it has been the law in the state of Georgia and commented and gone over by the Supreme Court of Georgia, especially as recently as 2015 in Duggar versus the state, D-U-G-G-E-R versus the state, 297 Georgia 120. And similar circumstances where a defendant was found not guilty of the malice murder charge, but guilty of the felony murder charge, and he claimed double jeopardy because only one person was dead and they came back not guilty on the malice. And in this particular case, Duggar, they said, no, that's not how this works. Appellant faced a single prosecution and he received a single punishment for murdering the victim. That's the quote from this. His double jeopardy rights were therefore not violated. In addition, he wanted to argue that these were inconsistent verdicts. Once again, the court held that that is not the case. There was no inconsistency between the verdicts of guilty on felony murder and not guilty on malice murder. Now, of course, in this case for Mr. Bryan, he's claiming, well, there was a series of felony murders. Well, the felony murders are predicated on certain underlying acts, and in this case, the jury did find him not guilty of aggravated assault with a shotgun and also not guilty of felony murder based on that aggravated assault with the shotgun. So therefore, their verdict was consistent in that manner, but they did find him guilty of aggravated assault with the pickup truck, false imprisonment, and criminal attempt at false imprisonment, and the felony murder associated with that. The state is going to, of course, argue that 2 of those felony murders will be vacated by operation of law and that Mr. Bryan will only be sentenced to 1 of the felony murder counts. And so therefore, based on Duggar as well as numerous other cases, and I believe Duggar was most recently cited in 2020 by the Strong case by the Georgia Supreme Court, that there is no sound legal basis in the state of Georgia for a double jeopardy claim, as well as numeration 22 on page 4 of Defendant Bryan's motion. Finding someone not guilty of a lesser charge doesn't necessarily mean they're not guilty of a more egregious charge. So the fact that they came back not guilty on those lesser charges versus the more heavy charge does not all of a sudden mean that it's a repugnant and or inconsistent verdict. We ask that you deny the motion. Thank you.
Your Honor, as Ms. Donikoski was so kind to point out, Duggar is readily distinguished. Obviously, malice murder is one crime, felony murder is another. Ms. Donikoski is confusing the merger concept with the double jeopardy issue. In this case, these are all felony murder counts. Well, they're all the same crime. So that is what distinguishes the Duggar case. And furthermore, with respect to the lesser offenses, Your Honor, the jury's verdict on the 3 lesser offenses of not guilty indicates that the jury concluded that an element of the offense, the greater offense, was missing. The verdicts are repugnant. I would submit they're repugnant as a matter of law, and that therefore the court must vacate count 7 as to Mr. Bryan. And that doesn't mean that there won't be 2 other felony murder counts left. It may be an academic discussion, but nevertheless, we're asking the court to vacate the conviction under count 7 as repugnant with the 3 misdemeanor counts and impose sentence on the misdemeanor count only.
Again, as previously indicated, the court received the motion this morning. I did take a look through the motion. We've taken a look at Duggar, the case is cited by the state, and the court denies the motion. I understand you've got one oral motion?
Yes, Your Honor. And I appreciate the court's patience. Your Honor, we are making an additional constitutional challenges to Georgia's sentencing scheme with respect to the imposition of the sentence of life without the possibility of parole. And again, as I think prosecutors suggested many years ago, a lot of the sentencing jurisprudence and criminal law jurisprudence began in death penalty cases with the theory that death is different. Well, I think the evolving case law over the last several decades has demonstrated that death is really not so very different after all. We assert 8th and 5th Amendment challenges to Georgia's sentencing scheme, which rightly gives judges broad discretion in determining sentences, but with respect to life without parole, that discretion is effectively unguided, as opposed to the sentencing scheme in a death penalty case for determining the imposition of the death penalty. Besides being cruel, the sentencing scheme also violates due process in that the statutes fail to provide sufficient guidance to the trial court. And therefore, Georgia's sentencing scheme is hopelessly ambiguous as well as arbitrary and capricious. Moreover, without any required findings of fact or conclusions of law, there is nothing for an appellate court to review to determine whether a sentence of life without parole has been lawfully imposed. Furthermore, we assert a 6th Amendment challenge, which I would call an Apprendi challenge, although it's not actually the authority, that any facts that increase a mandatory minimum sentence must be set, which in this case would be life without parole as opposed to a life sentence, that any fact that increases a mandatory minimum sentence must be submitted to a jury and found true beyond a reasonable doubt. And I cite Olen v. U.S., A-L-L-E-Y-N-E, 133 S. Court 2151, 2013. Blakely v. Washington, B-L-A-K-E-L-Y v. Washington, 542 U.S. 296, 2004. Your Honor, the jury acquitted as to counts 2 and 6. With count 7, it is impossible to determine what facts the jury found in this case because the state elected to pack so much into count 7. You've got parties to the crime, you've got principals to the crime, you've got the McMichaels pickup truck, you've got Mr. Bryan's pickup truck, and you've got whether it's an intent to injure or whether it's placing Mr. Arbery in reasonable apprehension of receiving an injury. There's so many different theories that the jury could have returned a verdict on that there's no way to draw any findings, meaningful findings of fact for sentencing purposes from the verdict that the jury rendered. And therefore, under these circumstances, there's nothing here for which the court could find a jury-found basis for imposing the sentence that the state is seeking in this case. Thank you.
Judge, on behalf of Mr. McMichael, we would join the motion.
On behalf of Greg McMichael, we'd like to join that motion.
Noted for the record. From the state.
Of course, the state's at a bit of a disadvantage, just having heard the motion, as is the court. However, the state's position at this point in time is this is a legislature issue. The legislature has passed 1651, and it is a mandatory life sentence. The court does have discretion between life or life without the possibility of parole. The complaint here, it sounds like, is, well, there's an Eighth Amendment violation, a Fifth Amendment violation, a Sixth Amendment violation because there's no guidance to the court. However, as this court is aware, the Supreme Court of Georgia has given Superior Court judges great deference because this court has heard the evidence. This court has seen the demeanor of the defendants, especially in this particular case, the demeanor of Travis McMichael as he testified. This court has seen the evidence from the witnesses on the stand and the body cam video of what took place. So in this case, the court is going to be given and has received the evidence in this case for its review to inform it and its discretion as to whether to impose a life sentence or a life sentence without the possibility of parole. I believe the next step in this process, of course, is going to be the state presenting victim impact and then argument. The defense will present its argument, all of which also informs this court and allows it to use its broad discretion and judgment as to whether to impose a life sentence or a life sentence without the possibility of parole. So we ask that you deny this motion. Thank you, Judge.
Final word.
Your Honor, with all due respect to Mr. Dunkowski, this is not a legislative issue. The Constitution is not up for discussion or negotiation. The Constitution is what it is. The Fifth, Sixth, and Eighth Amendments to the United States Constitution are the federal provisions at play here, in addition to the parallel provisions of our Georgia state Constitution. Legislators are politicians. They have to run for election, and they do what they think they need to do. And the job of the judiciary, as the independent third branch of government, is to put a check on that action when it violates our state and federal constitutions. So simply saying that it is a legislative issue, it doesn't address the question. And ultimately, it is for our courts to defend that Your Honor and the courts above you are the ultimate guardians of our state and federal constitutions and of the individual rights of individuals. And to simply say, or maybe that wasn't the suggestion, but one could interpret it that way, that the court should simply defer to the legislature as to what the Constitution means, to the extent that was their argument, is repugnant to our entire system of criminal justice. I'd ask the court to grant the motion.
All right. I didn't hear the argument quite that way, where the court has to defer to the legislature. There is a structure in place with regard to sentencing, and this court intends to adhere to that structure as established through Georgia case law. On that basis, the motion is denied. All right, I understand those are all preliminary matters. Then before the court, is the state ready to proceed with, and the way we're going to do it, as I understand it, is the state is going to present any evidence it has in aggravation as well as a opening argument. The defense is then going to have an opportunity each individually to present any evidence in mitigation if they wish to do so and make argument, with the state then having the rebuttal. That's how I understand we're going to proceed. From the state.
Thank you, Judge. Your Honor, for the record, today is Friday, January 7th, 2022. The jury returned its verdict on November 24th, 2021. That verdict was that Travis McMichael was found guilty on all 9 counts in the indictment. Greg McMichael was found not guilty of count 1, which is malice murder, but guilty on the other counts 2 through 9 in the indictment. Mr. Bryan was found guilty only as to counts 3, 4, and 5, all felony murder counts, and the underlying felonies corresponding to those felony murder counts, which were counts 7, 8, and 9. The court asked all of us to look into, with regard to Travis McMichael, the issue of potential merger as to the malice murder charge. The state has reviewed its own indictment and notes that It charged Travis McMichael, who was found guilty of count 1, malice murder, a human being did unlawfully, with malice aforethought, cause the death of Ahmaud Arbery, a human being, by unlawfully chasing him through the public roadways of the Satilla Shores neighborhood in pickup trucks and shooting him with a shotgun, contrary to the laws of said state, the good order, peace, and dignity thereof. As the state notes, this encompasses 2 different actions. Unlawfully chasing him through the public roadways of Satilla Shores, which describes the actions they did in the pickup trucks, and then shooting him with the shotgun. As the court will recall, defense filed a demurrer to count 1, saying this was surplusage and should be removed. The state's argument was that the state was not going to argue it was an either-or situation, and that is not going to be the state's argument here. The state's argument here is that factually, the state believes that count 8, false imprisonment, factually has been eaten up by the way the state charged count 1 in this indictment. In other words, count 8 and count 6 would merge into count 1 for Travis McMichael on the malice murder charge because of unlawfully chasing him, meaning Mr. Arbery, through the public roadways of the Satilla Shores neighborhood in pickup trucks. The reason we believe that that factually would merge is because count 8 is actually the false imprisonment charge. And count 8 does say, said accused did chase Mr. Arbery with a Ford F1 pickup truck and a Chevy Silverado pickup truck through the public roadways of the Satilla Shores neighborhood and did confine and detain Ahmaud Arbery. As the court is aware, the statute has nothing to do with chasing. That is descriptive language factually. The statute has to do with confining and detaining the victim. The fact that the state used up factually both the chasing in count 8 and the chasing in count 1 means both count 6 and 8 would then merge into count 1. I believe, and I could be wrong, but I will address this, that the defense may argue that count 7 and count 9 would also then merge into count 1 malice murder. However, the state's argument is that is not the case. The reason for that is count 7 is the aggravated assault with the pickup trucks. Did make an assault upon the person of Ahmaud Arbery with a Ford F-150 pickup truck and a Chevy Silverado pickup truck. An object, device, or instrument, when used offensively against a person, is likely to result in serious bodily injury. That, of course, factually can be a number of different things, and what the state did argue in closing argument was pulling up next to somebody, startling them, could put them in reasonable apprehension of receiving serious bodily injury. The state also argued in its closing argument that Travis McMichael, despite his testimony, actually used his pickup truck to pull in front of Mr. Arbery and cut him off, which caused Mr. Arbery on Burford to turn around and run away. So the fact that the jury found that they used their pickup trucks, objects which used defensively against a person are likely to result in serious bodily injury, did create an aggravated assault for Mr. Arbery, does not merge into count 1, which was unlawfully chasing him through the public roadways of Satilla Shores in pickup trucks. They are 2 separate and distinct things, especially when we have video evidence of the McMichaels pulling up next to Mr. Arbery then running away. That itself right there is an aggravated assault. He was obviously startled. He obviously was trying to get away from these men. They pulled up next to him. Reasonable apprehension of receiving serious bodily injury. With regard then to count 9 is criminal attempt to commit the felony of false imprisonment. As the court will recall, the defense also demurred to that particular charge in the indictment. That particular charge in the indictment did have an "and" in it, which, as the court knows, is an "or," which the state explained in its closing argument to the jury. In this particular count 9, it did charge the defendants with unlawfully chasing, or did unlawfully chase Ahmaud Arbery through the public roadways of the Satilla Shores neighborhood in pickup trucks and did attempt to confine and detain Ahmaud Arbery without legal authority on Burford Drive using a Ford F-150 pickup truck. In this particular instance, the state did argue and did inform the court in the demurrer response that it was going to argue and/or, because as we know, a criminal attempt is just a substantial step toward committing that particular felony. And as the court will note, count 8 took place on Holmes Drive, whereas count 9 was on Burford. So they don't have anything to do with each other. They're two separate incidents at two separate points in time based on the evidence in this case. So either one could be considered a substantial step, and because the and in between unlawfully chase and did attempt to confine and detain is really an or for the purposes of this, and once again, the state put that in its response to demur by the defendants, and the court denied the demur. That was filed by the defendants. The state also argued in closing argument that that was an or. They could find it that he was chased. They could also find that on Burford they did attempt to confine and detain him, especially with Mr. Bryan's actions of trying to run him off the roadway from his driveway, and with Mr. McMichael's actions of cutting him off at the end of Burford. So in this particular instance, especially with the criminal attempt, it does not merge into malice murder simply because of the words did unlawfully chase him through the public roadways contained in count 1. Therefore, when it comes to Mr. Travis McMichael, the state's position on sentencing and merger is this: that he is looking at a life sentence on count 1, malice murder, that counts 2, 3, 4, and 5, all felony murder, would be vacated by operation of law. Count 6, which is the aggravated assault with the shotgun charge, would factually merge into count 1. Count 7 would remain standing. And count 7 is a potential sentence of 1 to 20 years on the aggravated assault with the pickup trucks. Count 8, in the state's opinion, would factually merge then into count 1. False imprisonment, of course, is a 1 to 10 potential sentence. And count 9, criminal attempt, cuts that sentence in half. So count 9, criminal attempt to commit false imprisonment, is a potential of 1 to 5 years. Therefore, the minimum sentence that this court could impose on Travis McMichael would be life with the possibility of parole with 15 years, and that court could suspend, probate, run concurrent with that particular sentence. The maximum, and that is what the state is asking for in this case, is a life without the possibility of parole. The state did file its notice of its intent to seek life without the possibility of parole back in 2020 when this case was first indicted. So the state is seeking life without the possibility of parole as to count 1. Counts 2 through 5 are vacated by operation of law. Count 6 would merge into count 1, leaving then count 7 and 9, which would be 25 years. We are asking that that 25 years be a 25-year sentence, but to be run concurrent if the court chose to impose a life without the possibility of parole sentence. And that would be count 7 concurrent with count 1, 20 years to serve. Count 9 concurrent with count 1 consecutive to count 7, thus making it a total of 25 years running concurrent with the life without the possibility of parole sentence on count 1 for Travis McMichael. And that is what the state will be requesting and seeking. With regard to Greg McMichael, he was found not guilty on count 1, malice murder. He was then found guilty of counts 2, 3, 4, and 5, all felony murder. The state is seeking, therefore, a life without the possibility of parole sentence on count 2, which is felony murder based on count 6, which is the aggravated assault with the shotgun. Counts 3, 4, and 5 would be vacated by operation of law. Count 6 would merge into count 2, the felony murder. In this particular case, that felony murder only alleges did cause the death of Ahmaud Arbery based on the aggravated assault with the shotgun, so we do not have the same issue with language of chasing in count 2 of this indictment. This would, of course, leave count 7, count 8, and count 9 available for sentencing. Count 7 is aggravated assault with the pickup trucks. That's a potential 1 to 20-year sentence. Count 8, false imprisonment on Holmes Drive, a 1 to 10-year sentence. Count 9, criminal attempt to commit false imprisonment, a 1 to 5-year sentence. So the minimum Greg McMichael is looking at is life with the possibility of parole and 35 years. That 35 years can be run concurrent, it can be probated, it can be suspended. The maximum Mr. McMichael is looking at, Mr. Greg McMichael is looking at, is count 2. The state is going to be asking for life without the possibility of parole. Counts 3, 4, and 5 are vacated by operation of law. Count 6 would merge into that life without the possibility of parole sentence, and the additional 35 years to be run concurrent consecutive, meaning count 7 concurrent with count 2, 20 years to serve, count 8 concurrent to count 2, consecutive to count 7, and count 9, the 5 years to serve, concurrent with count 2, consecutive to count 8, resulting in a 35-year sentence to be run concurrently with the life without the possibility of parole sentence on count 2. With regard to Mr. Bryan was found not guilty of counts 1 and 2. He was, however, found guilty of the 3 felony murder counts, count 3, 4, and 5, based on aggravated assault with a pickup truck, false imprisonment, and criminal attempt at false imprisonment. The state is looking at a life sentence on count 3. Counts 4 and 5 would be vacated by operation of law. He was found not guilty on count 6. Therefore, count 7, the aggravated assault with the pickup truck, would merge into count 3, because count 3 is the felony murder based upon count 7. So count 7 would merge into count 3. Count 8, false imprisonment, potential 1 to 10 year sentence, and count 9, a potential 1 to 5 year sentence. Therefore, the minimum Mr. Bryan is looking at is a life with the possibility of parole sentence, plus an additional 15 years, which once again can be run concurrent, it could be run consecutive, it could be probated and or suspended. In this particular case, the state is going to make a recommendation for Mr. Bryan of life with the possibility of parole on count 3, with 15 years to serve consecutively on probation. And that is going to be our recommendation for Mr. Bryan. Your Honor, at this time, the state will go ahead and present its victim impact evidence for the court's consideration, and then once that's through, we will make our argument. Thank you. At this time, we're going to present Mr. Marcus Arbery.
I do want to make a point before we get into the victim impact statements, and not to imply that this would go any other way, but I do want to make sure that those that are addressing the court address the court as opposed to anybody else in the gallery. So let's go ahead and proceed. Good morning.
Good morning. How y'all doing? Right. It's a hard time with me and my family. You know something that I just doesn't sit right with me at this time. The man who killed my son has sat in this courtroom every single day next to his father. I'll never get that chance to sit next to my son ever again. Not at a dinner table, not at a holiday. And not at a wedding. He'll never get to have I pray that no one in this courtroom ever has to do what we had did, that buried their child. There's no word for that, because no word knows that much pain. Not only did they lynch my son in broad daylight, but they killed him while he was doing what he loved than anything, running. That's when he felt most alive, most free. And they took all that from him. When I close my eyes, I see his execution in my mind over and over. I'll see that for the rest of my life. When I became a father, my life became bigger than me. It became about my family, about protecting him, protecting my boy. I know in my head that there's nothing I could have done that day to have saved my son, to have protected him from that evil and hate. But my heart is broken and always will be broken because on my worst day or our lives wasn't there. If I could, I'd have traded places with Ahmaud in a heartbeat, but I can't. So I'm standing here today to do what he can't, and that is to fight for him, fight for his memories, his legacy, and to tell you who he was, because that's the one thing you didn't hear in this courtroom. And more than anything else, you should know who my boy was. We love our son, and we will never have him with us to celebrate anything. Thanksgiving, Christmas, or his birthday. His killers should spend the rest of their lives thinking about what they did and what they took from us. And they should do it from behind bars. Because me and my family, we got to live with his death the rest of our life. We'll never see Ahmaud again. So I feel they should stay behind them bars the rest of their life, because they didn't give him a chance. Thank the court. Thank y'all for what y'all did with our family stuck by us. Thank the jury. I give all glory to God. Thank y'all.
Thank you, Mr. Arbery.
Ms. Jasmine Arbery.
Good morning. My name is Jasmine Arbery. Ahmaud is my brother, and I would like to tell you a little about him. Ahmaud had dark skin that glistened in the sunlight like gold. He had thick, curly hair, and he would often like to twist it. Ahmaud had a broad nose, and the color of his eyes was filled with melanin. He was tall with an athletic build. He enjoyed running and had an appreciation for being outdoors. These are the qualities that made these men assume that Ahmaud was a dangerous criminal and chase him with guns drawn. To me, those qualities reflected a young man full of life and energy, who looked like me and the people I love. Ahmaud was funny. He told jokes to lighten the mood because he was a positive thinker. Ahmaud had a big personality and never missed the opportunity to let it shine. Ahmaud had a future that was taken from him in an instance of violence. He was robbed of his life pleasures, big and small. He would never be able to fulfill his professional dreams, nor would he be able to start a family or even be a part of my daughter's life. The loss of Ahmaud has devastated me and my family. So I'm asking that the man that killed him be given the maximum sentence available to the court. Thank you.
Thank you, ma'am.
Ms. Wanda Cooper-Jones.
Good morning.
Good morning, Your Honor. I want to first speak directly to my son, if I please. This verdict doesn't bring you back, but it does help bring closure to this very difficult chapter of my life. I made a promise to you. Today, I laid you to rest. I told you I love you, and someday, somehow, I would get you justice. Son, I love you as much today as I did today that you were born. Raising you was the honor of my life, and I'm very proud of you. Your Honor, these men have chose to lie and attack my son and his surviving family. They each have no remorse and do not deserve any leniency. This wasn't a case of mistaken identity or mistaken fact. They chose to target my son because they didn't want him in their community. They chose to treat him differently than other people who frequently visited their community. And when they couldn't sufficiently scare him or intimidate him, they killed him. My youngest son, he was born on Mother's Day of 1994. He had a smile so bright it lit up a room. He was a greedy baby that seemed like he was always searching for something to stick into his mouth. He was always a loving baby who seemed to never tire of hugs, cuddling, and kisses. He loved, he never hesitated to tell me, his sister Jasmine, and his brother Marcus that he loved us. And Your Honor, we loved him back. He was messy. He sometimes refused to wear socks or take good care of his good clothing. I wish he would have cut and cleaned his toenails before he went out for that jog that day. I guess he would have if he knew he would be murdered. My family is gonna miss Ahmaud. We're going to miss his jokes, his impersonations, his warm smile. These men deserve the maximum sentence for their crimes. Ahmaud never said a word to them. He never threatened them. He just wanted to be left alone. They were fully committed to their crimes. Let them be fully committed for the consequences. Your Honor, I'm standing here for you as the mother of Ahmaud Arbery, asking you to please give all three defendants who are responsible for the death of my son the maximum punishment in this court, which I do believe is life behind bars without the possible chance for parole. Thank you.
Thank you, ma'am. Any additional evidence and aggravation from the state?
No more additional evidence from the state, Your Honor.
Argument?
Your Honor, the state is seeking life without the possibility of parole for the McMichaels, based primarily on the evidence presented in this case. The state is not going to go through all of that evidence, just a few very important items. First off, there was a demonstrated pattern of vigilantism by Greg and Travis McMichael. First off, we have our July 13th, 2019 911 call after both of them went with guns to confront a homeless man who was living under the bridge, who they suspected must have been committing all of these crimes. Of course, all of these crimes included a lot of reports to 911 about suspicious persons, and as we heard from the witness stand and defense witnesses, a couple of unlocked cars with things stolen out of them by people outside the neighborhood. And then we have February 11th, 2020. Yes, Ahmaud went inside of the open, unsecured construction site that particular day. But Travis McMichael went home, got his father, they both got their guns, and then they went back down to that construction site. We know that because we heard the 911 call. And he says, I'm sitting outside the construction site. He talks about seeing somebody inside with a flashlight. The horrible part is we know from Brooke Perez, who testified for the defendants, that her husband had gotten a call from Larry English, and he'd gone over there with his handgun. We also know that the two men went inside with their handguns. It's a miracle they didn't shoot each other. And no one had called the police. Travis is outside in the pickup truck, finally calling the police. He stays on for about 4 minutes, and then Officer Ash appears. That didn't teach anybody here a lesson at all. Brooke Perez was trying to tell them, no, my husband's over there with a gun. Be careful, go in there. But Greg McMichael took off, according to Travis's statement, down the street and went right into that house. So we've got July 2019, February 11th, 2020. Not calling 911 first, not staying home, but wanting to seek out, in a vigilante manner, a confrontation with people that they suspect might be doing something that they themselves, up until January 1st of 2020, had not been the victim of. In all cases, they took firearms with them, did not stay home, did not allow the police to do their job, but instead, as on February 11th, Greg McMichael went in and started searching the house himself. We all know how that could have turned out terribly for him, for anyone in there, and for Diego Perez. All the decisions they made that led up to the death of Ahmaud Arbery. There were so many opportunities to stop, to think. And here's the real problem. Greg McMichael was former law enforcement, as they pointed out repeatedly. And Travis McMichael had served in the Marines. Not the Marines, the Coast Guard, as they pointed out repeatedly. So here we have some men who should have known better. Should have known better. Vigilantism always goes wrong. You wait for the professionals to show up. The professionals who are in marked cars, the professionals who are in uniforms, the professionals who are going to do it right because they have something to lose, the professionals with body cams, the professionals such as Officer Rash, who just would have stopped Mr. Arbery and said, hey, I'm going to put you on the phone with Larry English so Larry English can tell you to please not to come back. and they should have known that. They had alternatives. They had choices. But instead, Travis McMichael, who stated he was putting his son Everett down for a nap, who stated that his father had all these medical and health problems, didn't say, "No, Dad, I'm putting Everett down. No, Dad, you need to stay here." He grabbed his shotgun, which he stated was propped up in a corner in that house, to go with his father. And Greg McMichael was willing to get into that pickup truck and sit in a child's seat to go chase after Mr. Arbery. Greg McMichael attempted to control the narrative from the get-go at the scene. His statements were all about how they were justified, how it was self-defense, how Mr. Arbery attacked his son. When the unknown man came up to Greg McMichael at the scene, because of course the police hadn't put Mr. McMichael anywhere, told him not to talk to anybody. He was running around the scene talking to everybody. And when talking to this unknown man who walked up to give him water, he basically said, "No, this guy's an asshole. He is 20 feet from Mr. Arbery's body," referring to Mr. Arbery as an asshole. There's been no remorse shown, and certainly no empathy from either man. Because empathy would have said, hey, how must this look to this person that we're chasing? Are we terrifying this person? Are we scaring them? No empathy for the trapped and terrified Ahmaud Arbery. There was thoughtlessness as to the consequences, thoughtlessness as to the alternatives, there was vigilantism. And because of that, we are asking for Travis McMichael and Greg McMichael to be sentenced to life with the possibility of parole. Travis McMichael on count 1, malice murder, Greg McMichael on felony murder count 2, with the prior sentences or the underlying charges to run concurrent consecutive per the state's prior statement. The state is going to guess that the defense will probably say that these men served their country, they served the community. Travis in the Coast Guard, Greg McMichael at the district attorney's office, but we all know it is not the 99 things you do right, not the 99 good deeds that you do, but when you take another person's life, it can't be undone, it can't be taken back, there is no do-over. It's final, and that means caution must prevail. Thoughtfulness, empathy, and insight must prevail, not vigilantism. With regard to Mr. Bryan, his actions speak for themselves. He contributed to the death of Ahmaud Arbery in a significant way. The court is familiar with his actions. The court is familiar with his statements, with his level of cooperation with Agent Seacrest afterwards. And given his actions and statements in this case, the state is asking for a life with the possibility of parole sentence. And that would be on count 3 with 15 years consecutive on probation for Mr. Bryan. Thank you, Your Honor.
Yeah. Mr. Rubin.
Thank you, Your Honor.
Your Honor, for 150 years, judges in cases in which defendants were convicted of murder were authorized to impose a life sentence. That was the only sentence available. In 2009, the legislature expanded the judge's discretion and now allows a judge to impose both a life sentence with the possibility of parole and a life sentence without the possibility of parole, and gives absolutely, as Mr. Goff pointed out, no guidance to the court as to what factors to take into account when differentiating between people convicted of murder. But I know this court, Your Honor, has been on the bench long enough and has tried a number of cases, including murder cases, in which you've had to make those decisions. And you've had to differentiate between defendants and be consistent in your rulings, in your sentencing, probably the hardest thing any court has to do, which is to sentence a person to time in prison. In this case, in which the state is seeking the harshest possible sentence allowable under the law, we're asking the court to reserve the harshest possible sentence under the law for those who deserve it, for the worst of the worst. When the facts of the crime show a darkness of soul, a person so depraved and heinous as to shock the conscience by their actions, or where the offender is such a danger as evidenced by his past conduct or by his actions post-offense, such that rehabilitation is remote or impossible, those are the offenders who deserve the harshest possible punishment under the law. Those are the offenders who people would argue deserve to spend the rest of their lives in prison. Neither of those scenarios encompasses Travis McMichael or the conduct for which he was convicted. And like Ms. Donikoski, I want to spend just a couple minutes reviewing the conduct for which he was convicted, because I agree with something she said, maybe for the first time in this trial. When Travis McMichael woke up on that Sunday morning with his son Everett in his house, his goal was not to go out and kill somebody. His goal was to play with his kid. When he sat down for lunch with Everett, possibly with Greg and his mom, Lee, and sister Lindsay, his goal was not to commit a crime that day or kill somebody that day. His goal was to have a family afternoon. And when he was putting his son down at 1 o'clock or so in the afternoon, he was doing what every single person wants to and should be doing, which is taking care of their toddler son. When he got in the truck at his father's behest to find out who that person was sprinting down the road, his goal still was not to commit a crime. His goal still was not to hurt that person, but to merely investigate, to find out what was that guy doing back at the house where Matt Albenzi was motioning. And then 4 minutes later, Mr. Arbery's dead, Mr. McMichael's covered in blood, and we have what we have here and what the jury heard. And he was convicted. The jury found that his actions constituted malice murder, felony murder, and the underlying felonies. But this is not a case in which he just targeted someone recklessly, targeted someone without knowledge, misidentified someone. He knew Ahmaud Arbery. He had encountered him previously. And he had known about the fears that the neighbors felt at Mr. Arbery's continued presence. I'm not going to retry the case. The jury found that those facts did not add up to probable cause and did not justify Mr. McMichael's actions. But he didn't just go out and shoot Mr. Arbery. He only fired the shots, the fatal shots, when Mr. Arbery came at him and grabbed the gun, as Dr. Donahue demonstrated. These were not, and as reckless as those acts may have been, as Ms. Donikoski pointed out, as thoughtless as they may have been, they are not evidence of a soul so blackened as to deserve to spend the rest of his life in prison. This was not a planned murder. This was not a murder involving torture. It was a fight over a gun that resulted in Mr. Arbery's death. And for that, the jury found Mr. McMichael guilty. The state contends that 99 good acts don't overcome one bad act. And of course, legally that's true. Mr. McMichael is now a convicted felon. But 99 good acts do weigh in this court's consideration, do factor into what choice this court is going to make when sentencing Mr. McMichael to either spend the rest of his life behind bars or give him the possibility of redemption. And those acts, those 99 good acts, the court heard about those in the bond hearing. The court heard that during his time as a lifeguard at a camp for kids who have family members with terminal illnesses, that Travis McMichael actually saved the life of a boy who was drowning in the pool. The court heard that Mr. McMichael, while serving in the Coast Guard, literally saved the lives of family members who were on a boat that was taking on water. The court heard that Mr. McMichael saved the crew of a Coast Guard vessel while serving in the Coast Guard. The court heard of the letters of commendation given to Mr. McMichael by his superiors for various acts that the superiors said show superior dedication, selfless devotion to duty and consideration of others, and adherence to our core values, honor, respect, and devotion to duty. They don't excuse anything that happened on February 23rd, but when the court is weighing in the scales of justice what people deserve to spend their lives and then die in prison versus those people who deserve to be punished but then hold out hope for redemption, those are the acts the court should consider. Mr. McMichael was a devoted father to Everett. He had Everett 50% of the time, shared custody with Everett's mom, and in fact, early on was shown to be the more reliable parent, although I know that changed over time with his mom stepping up. He was a friend to many people who are now too scared to come to court and speak on his behalf. As the court knows from the testimony it heard in trial and at the bond hearing, he was always a hard worker, always had a job, never laid around letting other people support him, always paid taxes, always supported his community in a variety of ways. The discovery that we received is replete with FBI and GBI interviews of people in his community, people who told law enforcement officials of the times Mr. McMichael helped them when they were having problems, when their boat became unmoored, or when their docks were pulled off from storms, and Mr. McMichael was out there finding those things and bringing them back to the owners, or helping other people in the community, just as he thought he was doing on February 23rd. Actions that, in hindsight, turned out to be thoughtless, as Ms. Dunikoski said, or reckless, but were not evidence of an abandoned and malignant heart. Nothing in Travis McMichael's life suggests that he's a danger to society now, or will be a danger to society 30 years from now, after he has time to think, to work, to grow. When he's in his 60s, older than me right now, do we still want a person like Travis McMichael behind bars? There's nothing in his post-offense conduct that shows that he's either mentally unstable or a sociopath. He cooperated fully with police. He told the police everything he knew to tell them because he thought he was doing the right thing, even if that thing turned out not to be right. He and Greg McMichael thought they were helping their community. They thought they were helping the police catch someone who inexplicably had been in a house, and we still don't know what he was doing in the house, on 4 or 5 different occasions. He never fled. He never tried to obstruct the investigation. When he talked to his neighbors about what happened, he always expressed remorse and disbelief. If life without parole is reserved for the worst of offenders, those who are so scary, so unpredictable, and so likely to pose a threat in the future, then it is not appropriate for someone like Travis McMichael. The only purpose of a life without parole sentence, Your Honor, is vengeance. It's retribution. And the urge to seek vengeance is strong and understandable in the family. Lord knows if I was in their position, I would be seeking the same thing. But vengeance is not the foundation of our sentencing in our criminal justice system. Redemption is. Redemption is the belief that a person can learn, can grow, and still contribute after punishment. It is pointless to continue to punish a person who has undergone changes in character that distance him from the person who committed the crime decades previously. Travis McMichael, 35 years old now, should have the opportunity to show that he's grown, to show that he's changed, and the parole board, years from now, is in the best position to determine whether he should remain behind bars or can serve a useful purpose to society. Who knows where we will be as a society in 30 years? Why make a decision today that impacts so many people long after we're gone, long after you and I are retired, hopefully, but that binds the hands of those who will have to live with this decision 3 decades hence? Why make a decision today that snuffs out all possibility of growth, of redemption in Travis McMichael? Compassion for Travis McMichael and the humility to admit that we don't know what's going to happen in the future doesn't diminish the compassion that we feel for Ahmaud Arbery's family. Their loss is real and understandable. And their desire for the maximum punishment is real and understandable. But again, that's why we have judges imposing sentence and not the families of the victim. Because there are a lot of factors this court takes into consideration: deterrence, rehabilitation, retribution. Those are all valid factors. But the only thing an LWOP sentence serves is retribution. Wouldn't it be healing for Mr. Arbery's family for Travis McMichael to atone, to be able to express the remorse that's in his heart without the specter of a federal trial hanging over his head? We've heard several times today that he's shown no remorse, but this court knows that no lawyer would allow Mr. McMichael to say anything about his feelings towards the family while there were 2 pending murder trials against him. When the witnesses were interviewed by law enforcement about Mr. McMichael's conversations with them, to a person they said that he showed remorse, that he never wanted to kill somebody. He was merely trying to detain Mr. Arbery for the police. It is disingenuous and unfair to expect Mr. McMichael to express remorse with yet another trial beginning in 3 weeks, where everything he says can be used by the federal government against him. Wouldn't it be powerful, though, for Travis McMichael to look deep into himself and explore with the public, with his son Everett, why he did what he did, and in fact become a force for good while in prison and out, instead of one more old man behind bars costing taxpayers $50,000 a year or more in 30 years? Wouldn't it be healing to society for someone like Travis McMichael to be free to help heal the wounds that are certainly present in this country due to decades and decades and decades of discrimination, of racism? Wounds that we're just now beginning to try to heal. Judge, you can send a message that 4 minutes of conduct does not erase a life well lived. and that after punishment, there is opportunity for redemption. An opportunity that Travis can either take advantage of and prove himself worthy or not, and that the parole board can then determine whether he should be released from prison. We are not asking you to do anything, Your Honor, but to agree that we don't know today what the future holds. We're asking you to sentence him to life with the possibility of parole if it's earned. Judge, as far as sentencing, I would disagree with the state. I believe count 7 and count 9 do merge. I believe the language of chasing Mr. Arbery through the Satilla Shores neighborhood that is stated in count 1 and also stated in counts 7 and 9. Were used up, were subsumed, and would be therefore, would effectuate a merger of those crimes. In either event, this court has wide discretion in how it fashions this sentence. And we'd ask the court to exercise this discretion in favor of growth, in favor of redemption, in favor of hope, for not just the McMichael family, for not just Everett McMichael, but for the Arbery family and what Travis McMichael can prove himself worthy of in the future. Thank you, Your Honor.
Thank you. All right, I think we're probably at a good breaking point. Let's go ahead and take a break, let everybody get some lunch. We will plan on reconvening at, let's do 1 o'clock. It's just before 12 o'clock now, and we will continue with proceedings at that time. Thank you, everybody.
All right, so lunch break. This is going to be, as they believed, most of the day, sentencing hearing. Amazing, amazing things that we have heard from today. First, I want to go to Joey Jackson as our expert panel. Joey, the victim impact statements were amazing. They were emotional, 3 of them altogether, but the mother of Ahmaud Arbery respectfully addressed the judge, but talked to her son as she was giving this victim impact statement.
Has to be so difficult, Gene, and looking at these and dealing with them, you know, personally.